Hello, everyone. Good evening to all of you. My name is Caroline Mauricio. I will be moderating today's panel. I am a lawyer in Brazil. I am the coordinator of the International Relations in the Infrastructure Secretariat of Rio de Janeiro. I hold a master's degree in international law, and today I have the pleasure of occupying the position of Vice President of the Young Arbitrators Committee of CBMA. It is a great honor to have you all here with us tonight. Thank you, Anne, Claudio, and Joaquim for accepting our invitation. This is the second panel from our VisMoot Talk, and today we'll be discussing oral advocacy. Among the issues we'll be discussing, we'll have the following topics: key aspects for a good speech, how to manage pleading via Zoom, how to answer hard questions without getting lost or getting thrown off. To deal with these questions, we have three very special guests. And Ryan Robertson is a partner at Loki Lord in Houston, Texas. She acts both as arbitrator and counsel in international and domestic arbitrations. She has also coached the University of Houston's VisMoot team for 18 years. Joaquim Muniz is a partner at Trent Rossi Watanabe in Rio de Janeiro, Brazil. He acts both as lawyer and arbitrator in international and domestic arbitrations. He coordinates the practical course in arbitration, the CPA, which is the biggest course in arbitration in Brazil. And Claudio Finkelstein, who is a partner at Finkelstein Advogados in São Paulo, Brazil. He acts both as lawyer and arbitrator in international and domestic arbitrations. Claudio teaches both international private law and arbitration in the undergraduate and graduate courses at PUC São Paulo, and is also the university's VisMoot team coach. So without further delay, we'll start with Joaquim's considerations on the issues. Please, Joaquim, the floor is yours.
Thank you, Carolina. It's a huge pleasure to be here. Congratulations to CJA. That's a very interesting institutions that bring together young practitioners and maybe is the most vibrant young group in Brazil and the most talented. Congratulations, Carolina, for being in this role and to keep this ball rolling, like as a director of the CBMA that created the CJA. It's very it's a huge pleasure for us to see how it developed. It became a huge group of young practitioners with very interesting monthly meetings, if I'm not mistaken, and they do always very good webinars. And it's a very good idea to bring CJA to the VisMoot world, because that's the normal path of a student and a future arbitration practitioners. I see that a whole generation in this 10, 15 years of Brazil going to the pre-moot, the first step was going to a pre-moot, then join a young group, work in a law firm that does arbitration, and then you start building a career. And it's also a pleasure to be here with Claudio Finkelstein, one of the best professors in Brazil, and maybe the first one who decided to integrate the Brazilian students with the national students, to bring teams to the VisMoot. Claudio has been a pioneer, very successful, and also a pleasure to be with Ryan Robertson. Our former president, Claudio and I are members or fellows of the CIR, the Charter Institute of Arbitrators, and we were lucky enough to have Ryan as our president. So thank you for all you have done, and it's a sign of prestige for CJA to have Ryan in this event. So, but without further ado, I'm going to speak a little bit about oral advocacy, and I'm going to do some practical tips here. Can you see my screen? Mm-hmm. I won't go further than my 20 minutes. That's one thing you have to learn. The most important, to be on time, because you're going to the pre-boot and you cannot exceed your time. it's not good to keep asking for additional time. So I will give a good example here. I'll start with it's a presentation. Caroline asked us to speak both about oral advocacy in general and about oral pleadings at the VisMoot. And I start with some initial practical tips. The first one is that I start with the difference between real oral advocacy and the pre-moot. In the real case, you have to win the case. You are there to do whatever it takes for the client to win, because your client is being client, it's not you, but as opposed to the VisMoot, that's one being is not the claimant or respondent, but yourself, your performance. So you have to be careful because you're not there to win the case as if it were a real case, but to do better than opposing counsel. And that reminded me that old joke about the lion and two people walking in a savannah and found a lion, and someone took out the sneaker, start running, and the other say, but do you think that you're going to run faster than the lion? I said, no, I won't run faster than the lion, but I'll run faster than you. So it's a little bit like that at the pre-moot. What you need to do is to be better than the other team. What you need to do is to do a good oral argument. So I see sometimes the teams trying to solve the problem is the problems are always brilliant. They're very well crafted to be difficult, to be very difficult cases. So don't, and there are some dead ends. There are some cases there are some things that you don't have the perfect argument, but you are there to be judged as a student. There's an academical contest to know how deep you understood the concepts of arbitration law, how deep you understood the concept of CISG, and how well you can organize your legal research and your legal arguments. So that's what you should be careful about. You should care about doing a very deep research on the topics, show that you understand and you did research as good as you could, presenting your legal arguments in the best way. If some points you are in a weaker case, that's not a problem, because the ones we arbitrators that will judge you know about the weaker case, but they're not judging the case, they're judging you. So it's very important that you, when you do your oral pleading, don't try to come with some kind of gotcha moment that, oh, I have this revolutionary idea. No, you're not. You are there to present your argument, weak or strong, and to show that you did your homework, that you know how to present an argument, to know how to do the legal research. So be focused. I know that's very hard because at this time we are the pre-moot season, and you're confronting other teams and trying to get with some brilliant ideas. But more than getting to the brilliant arguments is to do your homework, to train how to speak well, to train how to speak on time, and to show the research that you did and show that you can convey a legal argument. Second point, initial point I'd like to convey to you is that sometimes the students memorize. It's not just the students. In this point, it's exactly like a real hearing. Some lawyers, not good lawyers, memorize the oral pleading and just say the things give the speech in a very artificial manner. Don't be artificial. Be fluent, show your case in a fluent way, and more important than that, adjust your pleading both to opposing counsel pleading and to the arbitrators. I've seen In some real, I'm not talking just about the moot, because that's about advocacy. As an arbitrator, and I've seen something wrong, and Ryan, please correct me because you're our boss. As arbitrator, like you have sometimes the lawyers sustaining an argument to say, no, I'm not interested in X. I'm interested in Y. Please explain me about why. That's the interesting. You as a lawyer, as a counsel, you have to adjust immediately. You need to be flexible because you are not pleading to yourself. And that's something that I say to my junior lawyers. You don't write and you don't plead to yourself. You are not convincing yourself. You are convincing a third person. So you have to listen. You have to see which arguments this person, you have to keep an eye on the arbitrators about body language, if they are nodding, if they are sleepy, and you have to adjust, like you give strength to things that resonates and you drop the points that are not well received, especially. I think that's a big mistake when opposing counsel starts and you don't address what opposing counsel said, because that shows that you are too much rehearsed. And you have to be natural. You have to plead the case. And you plead the case. It's like, I love law and economics. It's like game theory. You act not based on your behavior, but also based on the behavior of the other players. So you have to pay attention to the other side and adjust. Third point, take advantage of a weaker case, because they try to do a balanced case, but not always will have a balanced case. But if you get a good case and do a good oral pleading, sometimes it's your merit, sometimes it's just luck. But if you get a bad case and survives, don't say anything, idiot. You show that you're a good lawyer. So that's your time. When you have a weak case, that's when you can shine. So don't be frustrated if you're doing the weakest argument, because that's your time to show that you're a good lawyer. Because again, it's not the case that's being judged, it's you that's being judged. And us as a lawyer, something that I learned that was very important for my development. You have good and bad cases, but as a good lawyer, you have to be always ahead of the curve. You don't need to win a bad case, but you have to make a bad case much better than it was supposed to be. Argue the case instead of fighting against opposing counsel or the arbitrator. And that's very important. Someone like we arbitrators, we are there to have fun, to judge you and to have fun. So sometimes you want to piss you off, you want to make you mad, you want to challenge you, because you have to grade you. Like if I don't say anything, I'll make your life easy. I cannot compare you with someone else. I have to make both lives miserable and see who did better. So don't be angry. Don't be aggressive against the arbitrator or the opposing counsel. Say something that you didn't like. Arbitrators, arbitration it's a venue that's much more diplomatic than judicial courts, and you have to know how to say the strong things in a very gentle manner. That's why I say that number 5, emotional intelligence, is as relevant as IQ. If you we will put pressure on you to see if you are doing well or not. So you have to support the pressure. It's much, I think, VisMoot as advocacy in general, it's a game about emotional intelligence, not in as much as raw intelligence. Don't know if the term exists. And beware of cultural differences. That's very usual. For instance, in Brazil, that talk about like some open concepts. You refer to bad faith. In the case of this year, when you're talking about practices, I saw several students raising good faith. But don't take for granted that good faith for me is the same thing that good faith for Anne Ryan under Texas or New York law, or good faith under English law. So try to, when you refer to a concept, be aware that's really an universal concept. I think it's a slippery slope when you try to raise some concepts that have different meanings in different jurisdictions. So be aware of cultural and legal difference, because what you think that a strong argument for an English arbitrator, if you talk about bad faith, you're going to have totally different meaning. Last point, cultivate your English. I know that sounds unfair because you're not native speakers, but you're going to plead in English. And it's very important that you are clear and you don't rush, because you need to be understood. If you're not understood, you're not going to get a good grade. That's a little bit obvious, but we see people that get nervous and they want to finish, so they start speaking very quickly. Don't do that. Do in your pace. That's a sign of self-confidence. That's part of credibility. That I'll reach my second slide. And my second slide go back 2,000 years about Aristotle. That's Aristotle triangle. And that's used, it's been true for 2,000 years. Aristotle has a very interesting article saying like the triangle of persuasion, how you persuade someone, that you do on logos, that's logic. So in our profession is legal argument. So have to develop a strong legal argument. But it's a triangle, so there are two other sides. One is pathos. The second one is pathos. Pathos is the emotion, because law, it's about precedents, about legal rules, but it's also about the sense of justice. Nobody wants to judge, oh, I will give this decision and it's unfair, but that's the law. No decision maker wants to do that. So you have to convey the message to the decision maker, either a judge, arbitrator, or a professor, that whatever he or she is doing is fair, is just, is the right thing to do. So you have to convey a little bit of emotion. But be careful, because emotion is like salt or pepper. If you put too much, most people won't like it. So it all depends on the personality of the person. So especially when we're talking about international competition, if a lot of cultures don't put too much pathos, but it's good to put a little bit. It's like salt. You don't want to your food without salt. And third one, also very important, credibility. You have to pass credibility. And how you pass credibility in a VisMoot? You show that you read the cases. Sometimes as arbitrators, you make questions about the cases because you quote a lot of cases or you quote a lot of professors. Did you really read what they wrote? That's very important, because if you don't have credibility, if as a lot talking about real life, is as an arbitrator, you present a lot of very big research on our brief. But if I got something wrong there, I won't trust it. So put it aside. I say, I'll do the research myself. And you wasted all your research. So credibility is very important. And how you convey those three sides of the triangle. There's the French love to say la méthode. There's the method of arguing. I'm not doing the French way. But I would say like you can divide an opening speech, either a pleading in a VisMoot of oral pleading in a real case, in three parts, like a brief summary of our case, the opening, the developing of arguments, and the closing. it's very important that you start with a brief summary of a case. That's what people call elevator speech. Like if you were closed in an elevator with the arbitrator going from ground floor to the 10th floor, and you have just like 20 seconds, what would you say? That's very important because research today, and there are a lot of research because of the internet, shows that the attention of people is much stronger in the first 60 seconds. So have to start in the 60 seconds giving a summary so that you convey your message and people, arbitrators understand what you're talking about. It's very important to have a roadmap. Like after you give your 20, 30 seconds or 60 second summary of your case, then you say, I will say X, Y, and Z. Because then you show to the arbitrator what's behind your summary, what are the facts and legal arguments supporting. That's called the roadmap. Like you give your first opening speech, like a brief summary, then you say, I'll prove what I just said by saying X, Y, and Z. And that's very good for the arbitrators to follow what you're talking about. I will say 5 arguments, 1, 2, 3, 4, 5, and you see Anne Ryan, one of the best arbitrators in the world. She took a pen to write down what I was saying. Like she'll write as arbitrator 1, 2, 3, 4. She's paying attention. That's the importance of the roadmap. You got the attention of the arbitrator. Then you have to develop your arguments, and I'll show one of the techniques, the IRAC method, and it end up with a summary. And either in the VisMoot or in a real case, the summary have to be linked to the relief sought or prayer for relief, depends on which country you are. Like you have to show the link between everything that you said with what you're asking for. That's something obvious, whoever do litigation, because you're always asking for something, and you have to have this the link. Like I said all those things for 15 minutes because I'm asking for X, Y, and Z. And what's the IRAC? IRAC is there are many methods, but one of them I chose the simplest one because I just have 20 minutes. A method to develop the issue. So in all cases that you have, you need to say for you to decide this case, you have to solve the following issue. So in the IRAC means issue, rule, application, and conclusion. Issue is the issue that the arbitrator have to decide in the case. So this is a case about the enforceability of a standard terms. This is a case of a battle of forms. This is a case of the applicable law to non-arbitration agreements. That's the issue that the arbitrators have to decide. And that's very important because you bring the attention to arbitration. That's the issue. Second, then you have to show what's the legal rule applicable to the issue. You talk about that's the issue, then in your case, our CISG, that's very important. That's the issue, and the article of the CISG applicable to this issue is Article X, Y, and Z. Then you show then you go to the A application, how the factual evidence in the records brings the application of the rule. And then you conclude. So it's issue, rule. When you establish what's the rule, what's the legal provision applicable to the issue, you show that the facts of the case support the application of the rule, and then you conclude. In real life, IRAC might end up being IRA, because you have the issues, sometimes have many rules, so have to go one by one, like this one of the rules, and that's the fact that support, that's another rule applicable, and the facts that support. It's very important that you don't choose more than 7 or 9 issues, because otherwise the arbitrators won't paying attention. That's a very interesting research saying that nobody can memorize more than 9 numbers. That's why telephone numbers in Brazil have at maximum 9 numbers. And in countries where they have more than 9 numbers, you never say one digit, to start saying 2 or 3 digits together, because the human mind is not made to memorize more than 9 things. So choose your 7, 9 max issues. Don't make too much issues first, because you're gonna go over time, like as I'm doing. And second, because the arbitrators don't pay attention. It's better to have a smaller range of issues, but very strong issues. Of course, there are alternative arguments like CREAC. You can start with the conclusion. Sometimes when you do legal memos, because the client won't read it anyway, just want the conclusion, we start and end with the conclusion. That's what we call CREAC. And sometimes you develop more, do conclusion, rule, proof of the rule, you do explanation like you have crack. You have many variations, but important thing, I think you could start by IRAC. You spot the issue, you say which rule applies, you show how the case, you demonstrate how the effects of the case support the application of the rule, and then you conclude. Time is of the essence, and I'm running out of the time. So prepare to make your case in half of the time. I did the opposite. I prepare to do in double the time. So to learn, you have not to follow what I'm saying. But it's very important for you to train against the clock. When I do my oral play for my case, I do 3-4 times against the clock. It's very important to do against the clock, to make sure that you're going to make it, and do to be much shorter than your time, because you're going to be asked by the arbitrators. And I go to my last slide, that I think that oral pleading is kind of cross-examination of students. We go to the moot as arbitrators to torture the students, to make difficult questions to the students. So you have to be prepared. As my witnesses are prepared for the cross-examination, you have to be prepared to be asked very difficult questions. So you have to train, like most of your preparation should be based on how to answer the difficult questions. You cannot be surprised. If a witness that I prepare is surprised by a question, that's my fault as a lawyer. I should have anticipated, and I should have tested this question to my wisdom. And you as a student, knowing that arbitrators will try to make the most difficult and the most complicated questions to you, should be prepared and anticipate. That's all I have to say initially. Thank you.
Thank you, Joaquim. Now we'll hear Claudio, please.
Thank you very much. I'll start by thanking Carolina on behalf of CBMA and the Youth Arbitrators Forum for putting up this event. It's indeed a pleasure to be here with such a distinguished panel. It's an honor to be once again with Joaquim, who you just introduced. I mean, we all know who Joaquim is. And then Ryan, which is our former president of the Charter Institute, longtime coach, someone involved in arbitration. So not to take up most of my time and reserve some time for answers, I'll try to avoid going over the topics that Joaquim has already covered. Although some of those topics I'll be covering with a different perspective. And by the way, I should start by saying that most Moody's, they already have coaches with some experience in mooting. And this on-hand experience is irreplaceable. So don't take for granted anything I say. I mean, this is my personal advice for my students and for other university students, which for some reason would rely on in our experience. So basically, my advice is follow whatever advice your coaches give you. Okay. I start using a saying. I actually Googled it to see who authored it, because it's so real. It's so truth. There's a saying that goes that the mind is a wonderful thing. It starts working the minute you're born and never stops working up until the moment you start speaking in public. So, I mean, it's just natural that you freeze, you freak out. I mean, you have all sorts of reactions once you start speaking, once you start your speech. So this is very natural. There is another saying, and this one is by Mark Twain, that says that it goes like that. There are two types of speakers: those who get nervous and those who are liars. So, I mean, I myself am a little nervous after 30 some years of lecturing in front of an audience. I mean, if anyone says I couldn't care less about it, he's lying. The secret is hiding your feelings. The secret is, I mean, it doesn't matter that you feel nervous as long as the people you're presenting your speech to doesn't notice you're nervous. So you have, and I have absolutely no recipe for that, but you have to control your nervousness in some sort of way. Some people, breathing exercises are probably the best, but I mean, everyone has his own recipe. Talk to your shrink, talk to your friends, your parents, your professor. You get thousands of different hints on how to control yourself. It is possible. I mean, that's something that you have to believe. I mean, just like Joaquim said, I've been mooting for 17 years now. I've seen every sort of student and every sort of arbitrator. And remember, we, the arbitrators and coaches, we get nervous too. So, I mean, we're pretty much tied up in this game. So, if there is a winning recipe for doing a great job at the moot, not winning, okay? Because to win, you need basically the perfect way. You need to do everything that you could possibly do. You need to be lucky. You need to choose carefully every single issue you're going to be dealing with. I mean, you have to be ready. You have to be prepared. You have to be responsive. You have to believe in your case. I mean, once, and this is something for those who have participated all through the drafting stage. It's really funny. It's probably the greatest exercise of mooting, because once you put on the shoes of the claimant, at the end of the writing stage of phase one of the memo, you believe the claimant is right. I mean, he did everything he was supposed to. There were a couple of flaws, but those are irrelevant. And I mean, the memo is being uploaded in the system. We used to say deliver, but now it's uploaded. The minute after, he's wrong. He has absolutely no idea what he's doing. He's a crook. He's trying to defraud the other party. So you have to believe. I mean, even if the case, just like Joaquim just said, the moot case is very well prepared, is well thought out. There is absolutely no way to say claimant or respondent will be the winner. I absolutely agree with Joaquim. This exercise is how you use your arguments and how you present your case. I mean, that's all about presentation. So when we say be responsive, is I'll go point by point, but I mean, you have to understand what's at stake. Not only when you get questions from the tribunal, or when you mirror the presentation of opposing counsel, you have to be aware of your environment. You have to be aware of all details of the case. You have to understand the question that's at stake during the presentation. So another thing that Joaquim said, which is absolutely a must, is timekeeping. Timekeeping is essential. If you have put up 14 minutes for your presentation, you take up 14 minutes, just like Joaquim said. I mean, sometimes you take more than half of the case, I mean, more than half of the time to introduce your case. That's a waste of time, but if it happened, it happened. You have to adapt. So having a good roadmap and sticking to it, it's really great. Sometimes the tribunal will break your legs. I mean, there's absolutely no way to anticipate what's going on and what's going to happen before or during the hearing itself. The tribunal could come to you and say, okay, you're going to be focusing on one single issue, which is boo. So, I mean, your roadmap is completely destroyed unless you have a roadmap for each specific topic. That has happened a lot, okay? We don't want to hear about standing. We don't want to hear about relief X, Y, or Z. We want to hear about that. And you have 15 minutes to deal with that. I mean, if the tribunal, I mean, they run the show. If they want that, that's not a democracy. That's not anything you're used to. It's not open for discussion. I mean, the tribunal, they have the last say, so that's about it. So first thing that, just like you said, I mean, you have to control yourself. So take a deep breath and be prepared. If you need a glass of water or a can of Coke or anything, pen, a book, I mean, anything to focus, I mean, get yourself whatever you need. Remember, mooting, it's about the same if it's online or if it's presential, but even though it's about the same, if it's presential, it's completely different from an online. I mean, it's about the same because you have to address the issues the same way, you have to present your case the same way, your pray for relief has to be presented the same way, but the way you do it, what we call delivery and actual advocacy, is completely different. It's a pity that we're going for the third time online, but I do hope most of you will have an opportunity to either, I mean, participate in one of the not many presential pre-moots, and maybe next year, maybe no, hopefully next year we're going like 100% presential. But I mean, whatever the case it is, you have to be prepared for whatever comes. You have to be able to use both your body language and your vocal language. And there is absolutely no recipe for what to do and how to do. I mean, you have to feel the tribunal. You have, I mean, how do I do that? It's something that either you have or you don't. And you have to look at the tribunal. Remember, you're presenting your case to the tribunal. You're not presenting to opposing counsel. You're not presenting to your coach. You're not presenting to any audience if there is an audience. You're presenting your case to the tribunal. So whatever kind of movement, whatever kind of questions, I mean, they usually ask questions. If they ask the question to your opposing counsel, it means that it's something that bothers them. Don't believe they just said that out of the blue. So you have to be attentive. You have to pay attention to what's going on. Not only the tribunal, but whenever opposing counsel is presenting their case, reactions from the tribunal, which might be summarized in questions or even, I mean, sometimes it gets scared. I mean, the tribunal will go, what? Like, I mean, if facial recognition is something to be taken into consideration. So another thing which is important, usually when you start muddled. Remember, you have to mesmerize the tribunal. You have to have pace, you have to have control. When I started by saying be prepared I mean, we take it for granted that you know the case by heart, you know your material by heart, you have case law, you have treatises, you have a lot of material, you have to know it by heart. You have to know the arguments of your opposing counsel, of course, if you come after him. But once you have it all, I mean, you know the law, you know the CISG, you know the UNCITRAL rules, you know the UNIDROIT. I mean, if you don't know that, you're just wasting your time. Chances are you're not going to advance to the second stage. I mean, this is a must. You need to know the case, you need to know the facts, and you need to know the law. Once you do that, you have absolutely no reason to be nervous. I mean, if you have what it takes, just go ahead and do it. Once you're convinced that you have it, you're probably better off than most of the people who does not have total grasp of it all. Just like Joaquim said, I'm not sure you should go over 7 to 9 issues. Usually, I mean, if you go like well prepared over 2 or 3 issues of either substance or procedure, it's probably enough. Because you usually have 12, 13 minutes, which means you have 4 minutes for each of the issues if you choose 3 issues. So you have to be able to identify which are the main issues. You have to address those issues in a timely manner according to your roadmap. By roadmap, I usually advise my students and anyone who asks me to have bullet points. So you have a page with bullet points. It's okay if you want to use it. I mean, even if it's online or thing, if you have a page, I mean, I will never advise you to read. I mean, don't read. But I mean, if you have a bullet point, you can go on the page and click. I mean, just get your pen and then you click. That's no biggie. Focus on the actual problem. What are the actual problems? You have to know the actual problems. Just like Joaquim said, I mean, the case is really well thought. It has the upside and the downside. There are some things that your client did which are killer. Sometimes you have to acknowledge it, move on, accept it, and minimize the impact of it. By sometimes, I mean every single time. And you don't have to stress it, but you have to know that those exist and deal with it. I mean, don't try to bullshit the tribunal. This is the last thing I would advise you to do. So by preparing that way, you probably know what are the questions that will be posed by the tribunal. If you know the answers, that's a lot better. Memorize your presentation. You have to know it by heart, but it doesn't have to be robotized. I mean, it has to be natural. So when I say memorize your presentation, memorize the bullet points, how you address it, how much time you spend on each of the issues will basically depend on your mirroring the presentation that came before your presentation, or adjusted to the reactions of the tribunal. So if you're addressing one issue that seems remotely interesting and the tribunal is probably not paying that much attention, you're doing something wrong. You have to work on your body language. You have to work on your impostation, your voice. You have to bring the attention of the tribunal. I mean, politely, of course, please. Remember, you cannot point at, hey, you, pay attention. You have to be really polite, drink some water, let something move. I mean, draw attention. Once again, remember, you're talking to the tribunal, not talking at the tribunal. Don't really bother if opposing counsel make faces or nods or whatever. I mean, this is not something that you have to worry. They will probably lose points if they do that ostensibly. You have to have a well-organized material, although presentially it's a lot more important, but it's a way to present your teamwork. Having well-organized and disposed material, it's a good way to present a good teamwork. Remember your posture, you're being marked, you're being evaluated for what you are and how you present it, and listen with a lot of attention to whatever the tribunal says. One thing that, I mean, this is the last pointer. I'm keeping track of my time, and I'll keep exactly 20 minutes. So remember, it's very, very important that you have the control of the English language, but you do not have to be fluent. I mean, in many, many occasions, you have teams from India or Pakistan or Scotland or Ireland with a lot of native speakers of English that you hardly follow their line of thoughts. I mean, you have a real hard time understanding. We have had finals with Germans with very heavy accents. We have had teams from South America in the finals with accent. I mean, this is part of life. Once I was in a class with Professor Gary Bourne, and he actually asked the people, I mean, what's the world's most widely spoken language? And most people would say Chinese or any other guess. And he said, no, it's broken English. And it is. And why is it called broken English? It's because it's broken. I mean, sometimes you cannot understand. If you're not understood, that's a bad sign. I mean, if you have an accent, if you have problems with verbal constructions, but if you get your message through, if you understand the question, and it's okay, sometimes you don't understand the question, not the contents of the question, but how it was posed or the English, you can ask, would you please ask again? Would you speak slowly? I mean, that's fine, that's acceptable. I hope I could help you with a few hints, and I hope we still have a few minutes to answer eventual questions. Thank you again, Caroline, and that goes my time.
Thank you, Claudio, and we're ready to listen to you.
Well, I have to echo what the people who have gone before me have said. First of all, thank you for this invitation. It is always a pleasure to be in Brazil, even if it is remotely this time. And the two speakers who went before me, Joaquim and Claudio, I think have covered very succinctly those things that you need to remember in order to be an effective advocate, not only at the moot, but in practice. But I want to, in some instances, reiterate what they've said, and in other instances, perhaps take a little bit different tactic, because I'm a common law lawyer and you've heard from two who are trained in the civil law. And one of the things we know about international arbitration is that it is a melding of the civil law and the common law. And so you will see practices that are taken from both. And the arbitrators that you are going to have at the Moot will probably be a combination of common law and civil law lawyers. So one of your challenges is, how do I best present to three arbitrators that have some things in common, but have some differences? And the first thing, and the most important thing, Joaquim mentioned this, Claudio mentioned it, you want to talk to the arbitrators. You don't want to read, you don't want to preach, you want to talk. And how are you able to talk to them? Well, part of it comes from having practiced and practiced and practiced. I have always told my students that you have to have the law and the facts and the entire problem in your DNA. That's how deeply you need to take it. It has to be in your DNA. Now, Joaquim talked about giving an elevator pitch, and I think we went from the first floor to the 10th floor for the elevator pitch, which it was, we have some pretty fast elevators, so you'd have to talk pretty quickly. I'd like to call that a little bit differently, and I would like to show you what common law lawyers often do, which is to develop a theme. And I'm going to give you a couple of real life examples. The first one actually came from an arbitration that we were involved in, and our clients' witness statements all mentioned this one individual and what this one individual had said. Now, this one individual was actually employed by the other side. And when the witness statements were put in, that particular witness did not put in a witness statement. And there were a few other witnesses still in their employ that they didn't put witness statements in. And so in our opening in that particular case, we talked about, where's Mr. X? You're not going to hear from Mr. X, but Mr. X is going to be discussed many times. And we developed this theme about where's Mr. X throughout the entire case. And in the end, when the award was written, the tribunal commented on the fact that Mr. X had not shown up and actually took an adverse inference from that. Now, common law lawyers develop a theme because we are used to doing trials in front of juries. And I'd like to give you two examples of two themes, both of which were extremely effective. In the 80s, there was a case called Pennzoil versus Texaco. Pennzoil, which is an oil company at the time, had sued had sued Texaco for interfering with their contract with Getty Oil. Now, they had no definite contract had been executed between the parties, and the parties were hotly contesting the evidence. But Pennzoil relied on the themes of oil patch honor, which is a Texas term, and a handshake is a contract. And they obtained a $10.50 billion jury verdict. The other example is actually in a criminal case, and this related to O.J. Simpson, who was being tried for allegedly having murdered his wife and another individual. And one of the pieces of evidence that the prosecutor was relying upon was, in fact, a glove. And O.J. Simpson made a big showing of that the glove did not fit his hand, at which point his attorney seized on the theme of, if it doesn't fit, you must acquit. And that's exactly what happened. So there you see, you're getting the attention of the tribunal with something more than just dry legal verbiage. Something else I'd suggest is to use analogies. You've heard a few today. Joaquim started out with one when he was talking about with the joke with the lion and running faster. I would give you another example that has just come out in a case here in the United States. We had a recent case that involves Section 1782. Now, Section 1782 in the United States allows people in other countries to obtain evidence in the United States to assist with a variety of things, criminal investigations, court proceedings, and the like. Well, the district court had said that they were trying to circumvent the laws of Nigeria because they had failed to use a treaty that the United States and Nigeria had. Now, this treaty is called the Mutual Legal Assistance in Criminal Matters, and they exist everywhere. And they said they were trying to circumvent that they were required to use that vehicle rather than using 1782 to obtain this information. And here is the analogy that the court said. First, the court said circumvent means to avoid an obstacle by changing the route. All right, so they looked at the definition. And then they said, for example, if two trains run from Lagos to Abuja, but one makes fewer stops along the way and therefore completes the journey in less time, a passenger who chooses the faster express train has not circumvented the slower train. And therefore, the court reasoned just because they had chosen to use a faster method, 1782, did not mean that they were circumventing the treaty. That's a classic example of using an analogy. And I would suggest that you try to see if, in fact, you cannot find an analogy that either you have in your argument or you have in your back pocket in terms of answering a question. I'd also like to suggest that you need to think about using short sentences. You don't speak the same way you write. And in fact, in your legal writing, stronger, more persuasive legal writing also uses shorter sentences. So think about that. And Joaquim talked about bad faith, and he's absolutely right. What bad faith may mean to me will mean something else to another arbitrator. And you have to be very careful of things that are emotionally and culturally loaded. And think about that when you're choosing your words. And now I want to talk a little bit what we call in the United States signposting. Now, let us assume that you've come up with your theme. And after you have done your elevator pitch or your theme, however you're going to handle it, you would typically then say, in my time before the tribunal, I will address 3 issues. And you would name each of your issues. 1, 2, and 3. And then you would say something like, and turning to the first issue. And you would repeat that first issue. Now, why are you doing that? You are signposting to the tribunal exactly where your argument is going to go. Now, after you finish that first issue, then you would say, and turning to my second issue, and you'd repeat that. And you would make your argument. And you would make your argument more likely than not, as Joaquim had suggested, using IRAC. Now, sometimes that works and sometimes it doesn't, and you're going to have to be flexible. And that's another word, flexibility. Because as Claudio mentioned, you're going to have instances in which the tribunal is going to ask you questions that throw you off your roadmap that you have. And you're going to have to be able to, 1, answer that question, and 2, get back to your roadmap if there's time to get back to your roadmap. I've always suggested to my students that they come up with a 10-minute argument, a 12-minute argument, and a 14-minute argument, so that if they start getting bombarded with questions, they're able to adjust so that they will still be within the time limitations. And I concur with Joaquim and Claudio that, in fact, it is extremely important to stay within the time limits if at all humanly possible, because it leaves a bad impression if you have to ask for more time. Even if the arbitrators have pounded you with questions while you're asking for more time, it sounds like maybe you can't manage your time. So you may want to think about preparing 3 or 4 different types of speeches so that you can deal with time issues. Questions. This is key. You're going to be asked questions by the tribunal. Now, some tribunal members may interrupt your argument to ask questions. Other tribunal members may sit there absolutely stony-faced, never ask you a question at all. Others may wait until the entire process is over and then ask you questions. And then there was one very notorious tribunal member in Hong Kong who might ask the claimant a question during the claimant's case and then turn around immediately to the respondent during the claimant's case and say, and how do you respond to the claimant's position? So you have to be attuned, you have to be listening, and you have to be ready to answer questions. Now, how do you answer a question? In the fewest words possible. Start your answer with yes or no. And then if you need an explanation, you can put it after the yes or the no. But if you give long, lengthy answers, it indicates that you haven't thought about that particular question. You should be able to answer any question in 1 to 2 sentences. So how do you do that? How do you prepare for that? Well, the best way to do that is to get your team members to ask you questions. And the crazier, the better. I remember one year we were preparing, and the brief writer that I had on the team was asking some of the most off-the-wall questions to the team members. And they were doing pretty well on coming up with answers. And lo and behold, some of those actually were asked by the tribunal members. So be prepared for having questions that might lead you to believe that maybe this tribunal member doesn't really understand the case. But you must always be extremely respectful when answering the questions. And if in fact a question has been answered by claimant and you're now respondent, it's a very strong thing to do if you can work into your argument that, and as Mr. Arbitrator ask and repeat the question, the position of the respondent is, and answer it for your side as well. Now, something that neither Claudio or Joaquim spoke about is rebuttal. Rebuttals need to be crisp. In my opinion, and they may not agree with me on this, in my opinion, they're 2 sentences, they're 3 sentences, they're 1 issue, and you choose your best issue. Now, how do you prepare for that? Well, you do that by looking at the other side's arguments, and you can make up rebuttals. They're obviously going to argue this. How do I rebut that? They will have to argue this. How do I rebut that? And work up some canned rebuttals. Now, when I say canned, it doesn't mean that when you give that rebuttal that in fact you are going to go as if you're memorized. Oh, no, no, no. I agree wholeheartedly. You should never appear that you're memorized. It's going to be heartfelt. It's going to be prepared, and it's going to be short and crisp. Now, one aspect of oral advocacy that can be very effective is to figure out a way to repeat. Repetition can be persuasive. I saw it used in a rebuttal one time. It was actually one of my students, and it's like the best rebuttal I think I've ever seen, and I can't take credit for it. The respondent had used the word simple, just the word simple, a couple of times in its presentation. And the claimant came back in the rebuttal and says, the claimant agrees with respondent. It is simple. It is simple to, and she stated what the position we had was, it is simple to, and she stated the next thing, it is simple to. Very, very effective. Now, in terms of presenting in front of a camera, like I'm doing now, or in front of the tribunal in person, 2 very different techniques. Because presenting in front of a camera, of course, it's 2D, not 3D. It's more difficult to see hand motions. It's more difficult to project energy. And so one of the things you might want to do if you feel like you're not projecting energy is to sit up on the edge of your seat. That will require you to sit up higher. And do think about inflection and pacing. Pauses can be very effective. Think about all of these ways that you can vary your verbal presentation. One other point I'd like to make is don't answer a question with, I think, or I believe. it is better to say claimant's position is or respondent's position is. And avoid saying things like, my learned colleague. That's a holdover from the English, and no one says it but the English, and it's really a stab at the other side. You want to always be professional. So what you would do is you would say something along the lines of, respondent maintains that we do not agree. So those are some very high level things on oral advocacy, and I have a little time left, and I know that you have your briefs already in, but I wanted to share with you a few tips as they relate to written advocacy. Why am I doing this? Well, I know the memorandum are in, but at some point you're going to be in practice and you want to be an effective advocate. And the written word is extremely important in international arbitration. So how do you first go about creating your memorandum? Well, the first thing you should do is to create a persuasion map. And you're going, a persuasion map? The way you do a persuasion map is you list the topics that you wish to cover. That would be the main issues. And below each of those, and you'll remember the IRAC, below each of those, you're going to put the authorities and the facts that support that particular topic. I always suggest that in creating the persuasion map that you do each topic on a separate piece of paper. Now, why is that? Well, I'm not one of these that can necessarily sit down and do my outline from A to B to C to D perfectly, but I can do each individual topic perfectly, and then I can move those pieces of paper around until I have them in the order that I want them. Now, you've got your main topic, your main issue, and you may have a subdivision under that. And sometimes you'll find that you may need to rearrange that. I say that creating an effective memorandum is almost like doing a jigsaw puzzle, because you take the pieces and you put them in and you move them around until ultimately you have the picture you want. Now you look at your first topic and you're going to need to come up with your heading. What is going to be your heading for that topic? What is going to be that issue? Make it concise and make it persuasive, because that particular topic, that particular statement that you make is going to go into your table of contents. And if you've done your table of contents correctly, and you have done each of your issues, your topics correctly, when I look at the table of contents as the arbitrator, I can see exactly where you're going with your argument, exactly what your position is. You need to make certain that these headings and subheadings are crisp and parallel. And by parallel, I mean make certain that they're all the same tense. If you're talking in the present tense, they should all be in the present tense. If you're talking in the past tense, they all need to be in the past tense. And now it's time to begin your writing. And as Joaquim said, you're going to have your topic sentence. Then you're going to have your rule, if there is a rule. And then you're going to have your facts and your argument to support it. And then you may or may not have a conclusion as to each little section. It may be more appropriate that your conclusion is at the end. It will just depend on the facts of your case. I told you that you should speak in short sentences. Use short declarative sentences in your briefing as well. Avoid long sentences. Avoid adverbs. The one that you hear arbitrators talk about time and time again is the use of the word clearly. Clearly he's right. Clearly he's wrong. If it were clearly, there would not be a dispute. So drop the adverbs. And if you've got adverbs in there, drop them out and see how much stronger it is without them. For instance, if I had the defendant ran the red light at 70 miles per hour, clearly his recklessness was the reason for the accident. Now let's read it without clearly. The defendant ran the red light at 70 miles per hour. His recklessness was the reason for the accident. That's a much stronger statement. Then you combine all these topics into your brief. In your memorandum, of course, you had to do a facts section, which was up front. Try to make it interesting. Try to tell a story rather than simply stating the facts. And dates can often be important. Now, you could say, on the 5th of January, the defendant stole the car. On the 8th of January, he ran the red light, causing the accident. Or you could say, on the 5th of January, the defendant, while high on meth, because that's one of your facts, stole the car. 3 days later, on the 8th of January, he ran the red light. There you are anchoring the time and adding some content to your facts. And now that you have put everything into the brief, it's time to review and revise. Look over your table of contents. Are all the headings parallel? Are the tenses the same? Does it tell the story? Now to the body. Of course, you're going to be looking for typos, but also, have you defined keywords and phrases so that there's no unnecessary repetition? Have you maintained consistent tenses throughout? How can you tighten your writing? Is that word "that" actually necessary? I think many times you will find that it's not. And here's an example. The sentence reads, for decades, Texans and the courts that serve them have experienced firsthand these consequences. So Texans and the courts that serve them. Well, sometimes you can do it by just moving to an adjectival form and saying, for decades, Texans and the courts serving them have experienced firsthand. You've gotten rid of that. Also, try to also get words of which, W-H-I-C-H. I worked for a judge, and one of the requirements was, after I had written his opinion, I was supposed to go on a witch hunt, trying to eliminate as many witches as possible. So keep that in mind as well. And then finally, I would suggest that in your preparation and in your presentation, have fun. It is a learning experience. Everyone does get nervous, and sometimes it's not going to go the way you think it should. And one last piece of advice that I would like to share, your coaches may not agree with this particular point. So you need to think and talk to them about this. Occasionally, you will find an arbitrator who is attempting to run over you. By this, I mean that arbitrator is not letting you make an argument. For example, a couple of years ago, we had an arbitrator. The student had made the first presentation, and the arbitrator says, well, is that your entire presentation? And her response was, well, no, Mr. Arbitrator, I do have an alternative grounds. And he says, well, I don't want to hear that. Now, what has happened here, he has not allowed you to do your presentation. And in doing that, he has actually forgotten what the purpose of the moot is, which is a learning experience. So how do you handle it? Well, your coach is going to give you some advice on that. I have suggested to students, and it's very difficult for them, to say something along the lines of, with due respect, Mr. Arbitrator, one of the bases for setting aside an award under the New York Convention is that my client does not have an opportunity to present their case, and with your permission, I should like very much to present my alternative argument. Now, that's very difficult for you as a student to say as an arbitrator, and your coach may not agree with that position, but I do think you need to be prepared that sometimes they will try to cut you off. Now, that is different from the arbitrators, and Claudio talked about this, coming in and saying, well, we only want to hear arguments on issue number 3. They're being equal to both sides. That is the one issue they want to hear. And this also goes back to what Claudio suggested as well, and that is that sometimes They will come in and they will say, I want to hear issues 3 and 4, but I want to hear them in the order of 4 and 3. So you have to be prepared to be flexible and to make certain that, as I started this in presentation, that you have this problem, you have the facts in your DNA. Thank you.
Thank you, Wen. I have a question. Well, it's actually more of a curiosity. If you could give one advice, just one key advice to the VisMoot competitors, which one would it be?
Out of everything that I've said?
Yes, just one.
DNA. I started with DNA, I end with DNA. You are not going to be an effective advocate if you do not know the facts and the law in such a manner that you can't forget them, that you can't be rattled. And that if you're rattled for a second, it's going to come back to you. That is key. And so it goes to preparation.
Claudio, Joaquim, we'd love to hear you too.
If I'm to pitch in, I have to agree with Van. I mean, be prepared. Be prepared. If you want to have fun the way it's supposed to be prepared and go face your demons.
I would say it's like they say in real estate, it's location, location, location. In arbitration, is preparation, preparation, preparation. Do real hearings. I memorize the number and what's written in the document because they're the only way you can do cross-examination. Because you don't know what the witness will say, but if you memorize all the documents, you're gonna catch at first moment that his line will say that document C 132 says the opposite. Please show the document to the witness. It's all like as any provision of service, and we lawyers are service providers. It's about man hour. Like it's the effort that you put is key for your success.
Carolina, I just thought of one other tip that none of us mentioned that I would like to mention for the students. And what prompted it was Joaquim's comment about knowing the page numbers and so forth. When you are referring to the record to the tribunal, give the page number first. And it's if the tribunal will turn with me to page 4, paragraph 48, instead of saying if the tribunal will turn to me to paragraph 48 on page 4, because they're turning to the page first. And it kind of goes back to only remembering 9 numbers. Although after Joaquim said that, I looked, we have 10 numbers in our telephone numbers in the United States.
But how do you say that? You start with 312, 200, 212.
No, actually what we do is we have an area code that's 3 numbers. So everybody does those 3 and then we do the rest. But it's very important to think about what you're saying to the tribunal and how you want them to act. Okay, I want them to turn to page 48, and then I want them to look at the paragraph. And one of the other things is that you see is that people will give that direction to the tribunal, and then they won't wait for the tribunal to get there. And it's important to wait and let the tribunal get to the point where you're pointing out. And I think that's a little more difficult to determine on Zoom than it is in person, but you're just going to have to be attuned to that.
If I may, I also remember one issue that we didn't cover. It is, use your tools. Once you're beginning the presentation, you have the names of the arbitrators and Google them. Just like Ann said, it's a multicultural experience. And sometimes people like to be pleased, so to speak. So if you have a German as an arbitrator, you should know what they like. And if you know who that person is, and if you have access to his teaching staff, he has worked and written extensively on damages or whatever he's done in his past. A lot of that you can find online. If you have this, use this.
That's a great, great tip. And of course, nowadays with everything being online, and I'm sure you remember from all the years that you were doing this, the students were lugging all the books with them and everything, and now everything is online. A good example of that is that one year we had an arbitrator who was also known to be a businessman. And the question related to fraud. And he says, well, you know, why should we be concerned about this fraud that occurred? And the student had actually thought it through, my heart sinking, like all coaches' hearts sink. And he says, you know, Mr. Arbitrator, you may not care as it relates to this case, but as a businessman, you should care about fraud. And the arbitrator made the comment later, you know, you came up with a business solution to a legal argument. So know your arbitrators and think about what might be a business type answer that could be given to any question that is given.
Thank you, Anne, Claudio, and Joaquim. It was very enlightening. I am sure that all of the competitors will take great advantage of everything that was said here. CGA thanks you. I hope we can receive you once again here. And good evening, everyone. Thank you.
Thank you. I enjoyed it very much.
So did I.